I just say to members, I've had a good thorough look through the bill. It seems to me that almost everything of substance is in the first part. There's not much anywhere else. So having said that, I'm prepared to allow this debate to go on a little bit longer, but I say to the House that on the other parts, they can expect a pretty short shrift from the Chair and a closer look at things. Now, I had, out of the corner of my eye, Moana Maki.
Thank you. Thank you, Mr Chair. And I appreciate the National Party don't like having to debate employment legislation because they know that what they're doing is absolutely unfair and absolutely not required. These changes that they're making in Part 1 of this bill are ideological and there is no other basis for it. And I want to start off by talking about the provision which removes reinstatement as a primary remedy for personal grievance claims. And I'll talk about the 90-day issue a bit later on. But of course this extends it to other people. We've been talking a lot about the 90 days, but what happens when you get into that period of employment where you're past the first 90 days and something happens and a personal grievance claim is taken? Now, if the employee is deemed to have been unfairly treated and, for example, if they were dismissed unfairly and the tribunal rules in their favour, it would only seem to be fair that that person could be reinstated. That reinstatement in the job that they should never have lost in the first place, and it has been ruled that way by the Employment Tribunal, it's only fair that they get to go back to that job if that's what they wish. Well, this legislation removes it. So what it says is that even once you get past that first 90 days, all you need to do is get rid of someone. It doesn't matter if it's unfair because now you won't have to take them back even if it's ruled that they should never have been let go from their place of employment. So in a way this almost extends the 90 days on in terms of removing that security for employees. It says to those employers out there who want to get rid of someone very easily that you can do it because you won't have to take them back even if you were wrong in doing so. And it strikes me, I cannot imagine why the National Party think that that is fair. Why they think that's fair. Because we know that employment law is all about balance. All about balance. You have to balance the rights of the employees and the responsibilities of the employees versus the rights and responsibility of the employer. Well, the National Party think that employees should have to bear all the risk in an employment relationship. They should have to have no security in that relationship, whereas the Labour Party believes that we need to strike a balance in the middle, which is fair to employers and fair to employees. And both sides aren't going to get everything that they want. That's part of being in that relationship. But Part 1 drastically skews the rights towards the employer against the employee. And we heard, the contribution by Tau Henare, I think, just showed how incredibly out of touch this government is with the reality for workers. Because he said, if Labor says that unions are really good when it comes to access to the workplace now, why is Labor fighting this change? Because that is not the case in every circumstance. And this is about a worker's right to support when something goes wrong in their workplace. It's about a worker's right to be able to call their union when something happens, when they're faced with when they're given an unfair employment choice, when they're worried about health and safety. And National says that those workers should not be able to have access to their union without the approval of the person who may well be the problem. And it's in those circumstances that the protection of the law is incredibly important, and that is what is being removed in Part 1 of this piece of legislation. Because we know right now, unions are voluntary organisations. They don't want to get offside with bosses. They don't want to have a bad relationship with employers. They work with employers for their employees and for their members. And they do so responsibly. But where there is a situation where a worker needs to have that support, the National Party now says that they have to get permission to have that support. And a lot of people remember when workers had to go and stand off-site on the road, on the footpath, to meet with their union, to meet with the people who represent them. Whereas, for example, a big company could bring in hordes of lawyers and no one says they have to have anyone's permission for them to have the kind of support that they want when it comes to employment law. But a worker who just wants their union organiser to come in, give some advice, maybe solve a problem, now has to get permission to do that. And that is a very, very dangerous move in terms of the rights of those workers and their ability to get the help that they need in the workplace. It's unfair. It's not needed. At Select Committee, no one could come up with a single instance of where this was a problem. The officials told us there was no problem. That's not true, Mr Woodhouse. When we dug down into it, there was no problem. Because when unions had to come on site without telling the employer, there was a very good reason for it. There was a very good reason for it. I am being truthful, Mr Bennett. I am being truthful. That member should be very, very careful, because his conduct at Select Committee as the chair was actually appalling on this piece of legislation. Absolutely appalling. Well, let's talk about the young woman who wrote to us to say, Mr Chair, Mr Chair, Mr Chair.
I call Carol Beaumont.